Welcome to this enlightening session on property rights of women in India. I am Dr. Shivani Gupta from University Institute of Legal Studies, Punjab University, Chandigarh. The issue of women's property rights has been a subject of legal evolution, societal debate, and judicial interpretation for decades. While the Transfer of Property Act 1882 primarily deals with the transfer of immovable property, it does not specifically address the rights of women in matters of inheritance and succession. This lecture aims to explore how different personal laws, Hindu, Muslim, Christian, and Parsi, govern women's property rights in India. Over the years, legislative reforms and landmark judicial rulings have significantly shaped these rights, but challenges persist in their full realization. By delving into the historical and legal aspects, this session will provide a comprehensive understanding of the strides made toward gender equality in property ownership and the challenges that remain. In this lecture, the learner shall acquaint with how property rights of women are governed under different personal laws in India, historical and legal developments in women's property rights under Hindu, Muslim, Christian, and Parsi law, the key provisions of the Hindu Succession Act 1956 and its amendments, especially the Hindu Succession Amendment Act 2005. Islamic inheritance laws and the shares allotted to female heirs, significant judicial pronouncements that have strengthened women's property rights. By the end of this lecture, learners will be able to differentiate between various legal frameworks governing women's property rights under Hindu and Muslim laws. They will be able to explain the historical and legislative evolution of property rights for women in India and will be able to interpret key judicial rulings and their impact on women's inheritance rights. Property rights of women in India are not dealt directly under the Transfer of Property Act 1882. The TPA only deals with the transfers of immovable property, and that too transfers inter vivos, that is, between living persons. This relevance of this law here in our case is that this law does not make any distinction between men and women in matters related to transfer of immovable property. The relevance of this law here in our case is that this law does not make any distinction between men and women in matters related to transfer of immovable property. The topic that we are going to study now does not fall in the immediate realm of the TPA because when it comes to the rights of women in property, it pertains to the rights of women, either daughters, wives, or mothers, in the property of their fathers, husbands, or children, respectively, upon them dying intestate. Thus, these provisions shall be better studied in the scope of the applicable laws dealing with succession. Further, it is important to again clarify that the TPA only deals with immovable property, while the relevant laws of succession encompass within their ambit the totality of the things having proprietary value, including both movables and immovables. In the present topic, the usage of the word property shall mean referring to both movable and immovable assets being the subject matter of transfer through succession. This topic is of immense relevance in the present day times when both the law and the judicial system have recognized that daughters should have equal rights in the property of their fathers, etc. We are a society which did not believe in parting with property with daughters because they were to one day get married and become a part of some else's family. The rights of women in property are not the same for all in India. They are actually dependent upon the applicable personal law to which the female is subject to. They vary from one religion to another. Let us see the property rights of women under Hindu law. For the purposes of studying this part, it is important to first keep in mind that under the Hindu personal laws, a Hindu shall include a Sikh, Jain, Buddhist, and even all scheduled castes and scheduled tribes who have born and brought up as Hindus. Property rights in India have traditionally been governed by a combination of religious laws, customs, and statutory enactments. Among these, Hindu law has played a crucial role in defining the rights of women in matters of inheritance and property ownership. Historically, Hindu women's property rights were significantly restricted due to patriarchal norms, but over the years, legislative reforms and judicial interventions have sought to bridge this inequality. Before independence, women's right to property were governed by the Hindu Law of Inheritance Amendment Act 1929. Women were allowed only limited rights as they were not entitled to independently own property but were merely entitled to maintenance. Further, the Hindu Women's Rights to Property Act of the year 1937 allowed Hindu women to enjoy limited estate in their husband's property for lifetime without giving them the rights of alienation. Post independence, the property rights of women were governed under the provisions of the Hindu Women's Right to Property Act 1937 and the Hindu Succession Act 1956. The 1937 Act basically dealt with the property rights of Hindu widows and granted her equal share to her sons in the property of her husband dying intestate. The main lacuna in this enactment was that it did not grant compulsory rights to Hindu women. This right was given to women by the 2005 Hindu Succession Amendment Act, which was guided by the recommendations of the 174th Law Commission report. Let us see Hindu women's right in compulsory. Compulsory property can be understood as that intestate ancestral property which are acquired by the members of a Hindu undivided family, commonly abbreviated as a HUF. The law that dealt with the intestate transfers of property amongst Hindus has been the Hindu Succession Act 1956. Under this act, only the male lineal descendants up to 3 generations, that is, the son, the grandson, and the great grandson of the intestate Hindu, were considered as coparceners and were entitled to acquire his property as a coparcenary property. Thus, the law did not give any such rights to Hindu females as they were kept out of the pool comprising of coparceners. This age old rule changed with the coming into force of the Hindu Succession Amendment Act 2005. This Amendment Act brought changes in the provisions of Section 6 of the Principal Act, introducing that daughters of a coparcenary in a HUF governed by Hindu Mitakshara law shall by birth themselves become coparceners in their own right. This brought a landmark change in the then ongoing discriminatory practice and gave daughters equal rights in the property of a HUF by according them the status of a coparcener. What is important to note is that the law is a very welcome and non discriminatory provision because under section 6(1) not only does it give the daughters equal rights in the coparcenary property but also makes them equally liable in respect of that property. Further, in case of a woman coparcener dies before her share had devolved on her under section 6 subsection 3, her share shall devolve upon her surviving children as it would have been received by her when alive. Similarly, in case of the death of a child of the predeceased woman copartner, the share of such child would devolve upon the surviving children of that deceased child as if he or she would have received had he or she been alive. Next aspect is Hindu woman's full ownership rights. Any movable or immovable property that a Hindu woman possessed through acquisition solely belongs to her. Section 14 of the Act gives her full ownership rights over such acquired property, whether the said properties were acquired by her before or after her marriage. Anything acquired through inheritance, partition, gift from a relative or a friend as maintenance or arrears of her own skill by purchase or even her stridhan shall all be considered as properties acquired and she has full ownership rights over them. Having full ownership rights connotes that she is not bound to receive any sort of permission from her father or husband or brother or even son for the sake of making decision pertaining to the use or disposal of her acquired properties either intestate or through a testament under the provisions of section 30. Before the 2005 amendment, only Hindu males could dispose of their property via will. The same right was not afforded to Hindu females. But now she has been given full rights to own and freely transfer such property and make good with the proceeds that she receives from such transfer. Over the years, the Supreme Court and the High Courts have played a pivotal role in reinforcing women's property rights through landmark judgments. In Pushpalata versus V. Padma 2010, the division bench of the Karnataka High Court gave retrospective effect to Section 6 since the passing of the Act, that is, June 17, 1956, and held that any daughter born after June 17, 1956 can claim benefit and reopen the partition if not registered or not by the decree of the court. In Dhanamma Suman Surpur versus Amar 2018, the court clarified that daughters born before 2005 also have an equal share in coparcenary property. This judgment reinforced the rights of married daughters, stating that marriage does not strip a daughter of her coparcenary rights. In Sehgal versus Sehgal 2018, the Supreme Court ruled that a mother has equal rights over the self acquired property of her son, emphasizing gender neutrality in inheritance. In the landmark judgment of Vinita Sharma versus Rakesh Sharma 2020, the Supreme Court ruled that a daughter's right to ancestral property is by birth and not dependent on whether her father was alive on September 9, 2005, the date of the amendment. This overruled previous judgments that had created ambiguity. Though India has come a long way in recognizing and protecting the property rights of women under Hindu law, the Hindu Succession Act 1956 and its 2005 amendment have played crucial roles in promoting gender equality in property ownership. However, challenges do remain in the form of patriarchal customs, legal loopholes, and enforcement issues. Judicial pronouncements have reinforced women's rights, but much work remains to ensure that legal provisions translate into real empowerment for women with continued legal efforts, awareness, policy reforms, and judicial enforcement. India can move toward a more equitable system where women's property rights are truly protected and upheld. Next, we'll go on to the aspect of property rights of women under Muslim law. Muslim law contains very complex property rights. Certain categories of persons are given very precise share. Of the Sunni and the Shia laws, the Sunni school of thought is broadly prevalent in India and precisely is the Hanafi school of law. Muslim personal laws consider women to hold half the worth of a man, and that is the reason why women hold half of the share to the share held by their brother in their father's property in inheritance. However, her control over this property is absolute and she has all rights to manage, control, and dispose of her estate both during and after her lifetime. Daughters have rights of maintenance and to residence in parents' house until their marriage. In case of divorce, the charge for maintenance reverts to her parental family after the expiry of iddat period, which is approximately 3 months. A Muslim wife has right to meher and retains full control over her goods and properties and has the right to same maintenance as her husband gives to his other wives. It is the liability of the Muslim husband to provide a fair and reasonable maintenance to his wife after divorce. Divorced or widowed mothers are entitled to maintenance from their children. A Muslim woman who has children can inherit up to 1/8 share in her husband's property and up to 1/4 if there are no children. Similarly, a Muslim mother can inherit up to 1/6 of her deceased child's estate. A single daughter can receive a maximum of half of her parents' property, while if they are more than one in number, then all of them in total can receive a maximum up to 2/3 of their parents' property. The Indian judiciary has played a pivotal role in interpreting and reinforcing the property rights of Muslim women. In Muhammad Ahmad Khan versus Shah Bano Begum 1985, the Supreme Court ruled that a divorced Muslim woman is entitled to maintenance under Section 125 of the Code of Criminal Procedure, which applies to all citizens irrespective of religion. This verdict reinforced the rights of Muslim women to claim maintenance, highlighting the supremacy of constitutional provisions over personal laws in matters of fundamental rights. The landmark decision of Daniel Latifi versus Union of India 2001 challenged the constitutional validity of the Muslim Women Protection of Rights on Divorce Act 1986. The Supreme Court upheld the act but interpreted it to mean that a divorced Muslim woman is entitled to a reasonable and fair provision for maintenance extending beyond the iddat period, thereby ensuring financial security for divorced women. In the latest case of Tarseem versus Dharm 2024, the Supreme Court addressed the extent to which a Muslim individual can bequeath property through a will. The court examined whether a testator governed by Mohammedan law can execute a will for the entire estate or only up to 1/3 without the consent of other heirs. The judgment emphasized the need to balance personal laws with constitutional mandates of equality and non-discrimination. Another aspect that we'll be studying is the property rights of women under Christian law. The property rights of Christian women are dealt in accordance with the provisions contained under the Indian Succession Act 1925, hereinafter referred as the ISA. This law under Section 36 of the Act does not discriminate amongst males and females and entitles them to equal share in succession in their parents' property. Similarly, it does not discriminate in the rights of widows and widowers over the property of their spouses. When it comes to the rights of the widow in her husband's property, the rule contained under Section 33 of the ISA is the guiding principle. Under this provision, where the husband dies, leaving behind the widow alone and no lineal descendants or kindreds, the whole property shall devolve upon the widow. It is important to understand here that lineal descendants include son, daughter, grandchildren, great grandchildren, and so on, while kindred include distantly related persons. Where a Christian male dies intestate, leaving behind a widow and his lineal descendants, 1/3 of his property shall go to the widow and the remaining 2/3 shall be of his lineal descendants. However, if such a male dies leaving behind a widow and no lineal descendants, 1/2 of his property shall go to the widow and the remaining half to the kinders. Daughters are even entitled to shelter and maintenance from her parents before her marriage. As mothers, Christian women are entitled to maintenance in their children's property. However, if any of her children die, not leaving behind a living wife and children, then she can inherit not more than 1/4 of that child's property. A pivotal case that significantly impacted the property rights of Christian women in India is Mary Roy versus State of Kerala, 1986. In this landmark judgment, the Supreme Court declared that the Indian Succession Act 1925 would govern the intestate succession among Indian Christians in the erstwhile state of Travancore. Prior to this ruling, the Travancore Christian Succession Act 1916 was in force, which discriminated against women by providing them with limited inheritance rights. The Supreme Court's decision ensured that Christian women in Kerala would have equal inheritance rights as their male counterparts. Last but not the least, we will discuss what are the property rights of women under Parsi law. The property rights of Indian Parsi women are even dealt under the provisions contained in Chapter 3 of the ISA. Section 51 of the Act lays down same rules for the division of intestate property for both men and women. Under this law, if a Parsi man dies intestate, leaving behind a widow and or children or both, each one of them shall have equal shares in the property. If he is survived by one or both parents, then each of his parent shall get a share equal to half of the share that each of his children receive. This law does not discriminate between men and women, and thus Parsi women, both daughters and wives, have equal shares in the belongings of their fathers and husbands respectively. Section 50 of this Act further provides that if any widower or widow of such a person dying intestate remarries during the lifetime of the intestate, he or she shall not be entitled to get any share in his property. What is important to be noted here is that the property of the intestate only devolves upon his living children. If one of his sons died earlier, leaving behind a widow but childless, such a widow has no rights in the property of her father in law dying intestate. Thus, the recognition and protection of women's property rights have undergone significant transformation in India, with key legislative reforms and judicial pronouncements strengthening their position. The Hindu Succession Amendment Act 2005 has been a landmark step in ensuring that daughters have equal compulsory rights, while Islamic law, despite its fixed inheritance shares, provides absolute ownership to women over their property. In totality, women now have much better rights in property of their fathers, husbands, and even sons. They can own, sell, purchase, alienate their acquired property solely according to their sweet will. However, societal norms, lack of awareness, and procedural complexities still act as a major hurdle in the realization of these rights. Bridging this gap requires continued efforts in legal literacy, policy enforcement, and societal mindset shifts. Ensuring women's equal access to property is not just a legal necessity but a crucial step towards achieving true gender equality in India. Through legal awareness, streamlined judicial procedures, and proactive governmental policies, we can move towards a more equitable society where women can fully exercise their rights to property ownership. That's all for today's lecture. See you in the next lecture. Thank you.